recording. I'm going to share my screen. There we go. So you should just see the Think with a Drink.
Yep.
Okay, perfect. I'll give this another, we're not at 4:30 yet, so we will go from there. All right, so we're at 4:30, so I'm going to start this up just so we stay on time with these presentations. Welcome, this is Thirsty for Knowledge Thursdays, a weekly webinar presentation brought to you by the Ares Foundation for Financial Education, Inc. The goal of the Ares Foundation is trying to help everyone have a better relationship with their money. This week, we're going to be doing guardianship, conservatorship, and other legal documents. This is really a concern for all families, but we're going to lean a little bit in this with dealing with families with a child who has special needs, whether they're differently abled or they have a disability. Because when we talk about guardianship, a lot of times with families, Craig and I will talk about guardianship for those who have not reached age of majority. And in this case, we are going to be talking about what happens once a child does reach age of majority. All right, so just a little pre-flight checklist for everybody in the audience. So all the microphones have been muted. Your cameras, you can have them on or off. That's up to you. Zoom sort of lets that be a freewheel thing. I will say this, if you do have questions, we ask you to use the chat box. My navigator, Craig, and we'll introduce ourselves in a minute, will be monitoring the chat box. So if you do have questions, just feel free to use that if anything comes up. And Craig is also there to keep me on time so that we stay and try to get this moving along and on pace. Speaking of which, we are pilots for tonight's flight. Right here, I'm Tom Alessi. I am the president of the Ares Foundation for Financial Education. I am an investment advisor. I have been in the financial services for 21 years now. As an investment advisor, it means that I act as a fiduciary when dealing with my clients. Going to bring Craig in. Craig, why don't you introduce yourself?
Sure. I'm Craig Richardson. I'm the vice president of the Ares Foundation. Like Tom, I've been in the financial services business not quite as long, 16 years. And I work primarily with families and small businesses to help them reach their financial goals and put real plans in place.
Terrific. And as I said, Craig is my navigator for this flight this evening. We're going to be talking about guardianship. But if you do have any questions, use the chat box. I can't see them a lot of times, so he'll stay on top of that. As I said, these weekly webinars are brought to you by the Ares Foundation for Financial Education. We are a nonprofit organization. You can visit the site. It's www.aresfoundation.org. See a little bit about the information, what we do, how we do it. Really, our belief is that financial wellness is a contact sport. And we mean that literally. We mean that there needs to be guidance and engagement to go along with all of the tools and software that are available out there. Otherwise, you're just not going to get participation. And so that's really what we try to drive home, is that sort of one-on-one guidance and coaching that goes along with it.
It doesn't mean you should assault your accountant, right?
That is true. That is, not that type of contact sport. Now, what was that most recent one with the guy tackling the guy in the commercial? Couple of quick disclosures before we start up. These presentations that we do, they are meant to be purely educational, right? This is information that we share to everybody, and we ask, certainly we make them available on the website. We make them available on our YouTube channel. If you ever have any questions or anything, feel free to reach out, but we allow anybody to share them. We just ask that you use them for their basis, which is a purely educational use. With that, the Ares Foundation for Financial Education, Inc. is a nonprofit, and we are not affiliated with any broker-dealer or securities-related business. We are not a registered investment advisor. One of the things that Craig and I stress to everybody, and we go over this over and over and over again, that is, if you ever have any questions, whether they are tax, legal, or financial, that you seek out the help of a professional and ask those questions. One of the things with this is we do these and we call them Thirsty for Knowledge Thursdays, but affectionately we call it Think with a Drink, because we like to feel that you're going to be a little bit more relaxed, and we always feel, pouring a cold glass of something that you can relax and enjoy as you're listening and trying to take in the information and education that we're sharing is the reason that we do that. Tonight I am drinking Hammer. This is described as an oceanic pale ale from Revival Brewing in Providence, Rhode Island. I have no idea, but I'm giving it a whirl because I love the appropriation of the Jaws logo, and even on the can there's a quote from the movie, which is, you can ignore it right up until it bites you on the ass, basically. Craig, what are you drinking tonight?
Well, not quite as violent as yours with the whole Jaws, hammerhead Jaws thing going on, but once again, too, Rhode Island Narragansett, and I've got the lobster on there.
Oh, there you go, the summer ale from
Fresh catch. Yep.
From Narragansett. Well, if you choose to, great. If you cannot imbibe, we understand, but if you can pour yourself something to drink along with us, enjoy. I'm going to say skål as we start this up. It's very citrusy, the oceanic pale ale. I will say that.
Is it really? Yeah, there's a lot of fruit in the ocean.
Yeah, it's fruit at the sea, right? Yeah. Okay, so here's what we're going to be talking about and what we're going to be going through. The steps that you should be taking or should consider taking, right? We're going to talk about standard documents. And as I said in the beginning, a lot of this goes across, all families, whether they have a special needs child or typical children, documents that should be considered and that you should have. That's a will, that's a power of attorney, and we'll talk about some of the healthcare stuff. And then how that bleeds over into dealing with special needs. Then we'll get into the letter of intent. We'll talk about guardianship and the different levels of guardianship and going through that. And then how conservatorship is different from guardianship and going through that. We're not going to talk about anything to do with the trusts or ABLE accounts this evening. It's a completely separate topic. It's a little bit more involved. We'll probably do that when we turn the new year, and we'll come back with some we have a presentation that we do that's just on special needs trusts and 529A or ABLE accounts. All right, so the will, right? So this is, probably the most important instrument you can have drafted when you're talking about anyone. An individual, family, doesn't matter, because generally what the will is going to do is it's going to control where you leave or who you give your stuff to when you really break it down, right? Where is my stuff going to go? The issue that comes up if we have children who are under the age of 18 is without a will, unfortunately, the courts look at them as stuff. So the court is going to decide where your child goes or who's going to continue raising your child if you are no longer in the picture. And that's really when we start carrying this over and talking about dealing with a child who has special needs, why that's an issue and why that's a problem. You want to make sure that whoever the person is going to be the person who's going to be responsible and understand how to care for that child. That's the idea. You designate a guardian for your minor children. That's the other most important thing when you're dealing with it. I mean, in most cases for a family where it's husband and wife, it's I pass everything to her, she passes everything to me, and then we name somebody who's going to take care of the kids should both of us pass.
That's not always that easy, though. I mean, I got a lot of family members I care about, but I don't want any of them raising my kids.
Well, but that's why it's really something that gets involved, and we'll talk about that more when we get down the road with some of this, with the letter of intent and how guardianship, for in the special needs community slides over into adulthood as well. So what happens without a will is that it's basically state by state. The courts basically decide what's going on. A court names the administrator, they appoint the guardian, and there is no consideration because there's nothing to guide them as far as your wishes or what you wanted to see happen. That's what the will does. And so you always want to make sure that when you're dealing with this, that one of the first things, and Craig, how many times do we sit down with families, people with assets, with children, and there's no will in place?
Well, we ask them every single time, and I'd probably say less than 10% of the time there's actually something in place that's actually current.
Right. And, and that's an issue. And I will bring this up from time to time and going through it because it's one of the things that I've gone through and had to deal with, which is my youngest is 18 now. And to be honest with you, we didn't really even look at the will because we had done it when the first child was born and never changed anything because everything was in stirpes, which just means it goes through bloodlines. And there's stuff missing. And, it's just one of those, my wife and I finally had sat down and said, when my youngest turned 18, hey, we should really take a look and see if this needs to be updated or the stuff needs to be added in. And I'll go through that in a second when I talk about it. So Craig brings up a good point there with, you want to make sure that that gets looked at and addressed out over time. Right. So without a will, again, everything falls into the rules of the state that you're in, and specifically, the guardianship, right? Also your assets. And here's one of the things that comes up with that. We'll talk about it in a little bit. We don't go too much here because, again, we're not talking about the trusts or funding or ABLE accounts. But, realize that if your child, your son or daughter is going to be qualifying for benefits, the benefits are mostly going to be means tested. That means that there's a limit in terms of how much they can actually have in their name. And if you do not designate or separate where your funds are going, and they wind up getting your assets or some of your assets, it can then penalize them. It can disqualify them for being eligible for benefits. The state's never going to look at that. That's never going to be a concern or something that the state will deal with. So you just want to make sure that a properly written will take into all of those considerations, but specifically if there's just one child or multiple children, that the one child that has special needs or is going to be getting those benefits is designated as not receiving those assets from that. All right, one of the things that if you have gotten a will done in the last, let's call it, a lot earlier than my last 20 plus years ago, that you would get, there's usually 3 documents that they're going to give you. You're going to get the last will and testament, but you're also going to get a power of attorney. And the last one I'll talk about in just a couple of slides is a healthcare proxy. All right. So the power of attorney just says that this is, you're giving somebody the opportunity to act on your behalf. The durable, which is what most of them are written as, a durable power of attorney kicks in when you are unable to act on your own behalf. You've become incapacitated or you can no longer make those decisions or sign, mentally competent or physically able to sign off or register for something. That's generally what the durable power of attorney comes in for on that. And so, it allows somebody to act on your behalf for most legal things. You want to make it durable because then it's when you're incapacitated. Craig, what is giving somebody just general power of attorney means they can act on your behalf at any time.
Well, power of attorney, right? General power of attorney is before you're incapacitated, which that's where durable power of attorney is being placed if you become incapacitated, right? Regular power of attorney stops. So the other thing you need to be careful about is whenever you give someone power of attorney, they're you, right? So sometimes you want to maybe limit where they have that authority. So maybe you have over a certain bank account, but not over your retirement assets, or just got to make sure that they can't sell your home. They can't do.
Right. That's the point, right? That's the idea with that. You want to be careful as far as what you're giving them access or control of, as Craig said. It's a very good point in terms of that. So the rules, they do vary, again, state to state, as far as what's involved and how it's involved, how it's enforced or how it's looked at. Massachusetts fairly, very fairly liberal with that in terms of the oversight to it. but you just want to make sure if you're moving someplace else or you're dealing with family in another state, you just want to see how their rules are regarding that information.
Well, just before you move on too, Tom, it's another big thing too to make sure you have this between spouses as well. Sometimes people think that if I'm married, I automatically have power of attorney to sign for my wife or my your husband. That's not the case,
Right.
especially during durable power of attorney. If you're not already listed on that account, you have no signing power or no say over that account without having to go through the court now.
Right. And that brings up the point which is what I was saying, which is one of the reasons this came up in my world is that my daughter was supposed to be going to college, the younger one, and realized that we didn't have anything for her. And so wanted to make sure that we put something in place because if she goes away and something happens, we can't, my wife and I can't get involved. She's now 18. She's a legal adult. There's nothing we can do. If we have a general durable power of attorney, we can act or at least converse in that situation. And we'll talk a little bit as we get into the healthcare part of this in a second. So this is a broadly drafted, and that means open-ended, durable power of attorney will include some considerations and some thoughts as to being able to continue if gifts are being made. And this is where we get a little bit into the whole idea of trust funding or the ABLE accounts in today's world, where if you become incapacitated and maybe the concept was, over the next 5 or 10 years, I'm going to be gifting forward because I've got the ability to do that. But it's something that's in your head. It's not written down anywhere. Unless that's conveyed, then nobody knows that that's what you want to continue to do. And same concept as Craig was saying that, making sure that there's certain accounts that can be accessed and be dealt with. A lot of times we talk to people about future funding special needs trusts. Like one of the ways to do that is like with a life insurance contract. Well, those are premiums that need to get paid. So you want to make sure that if something happens to you and there's got to be a durable power of attorney, that person then has the ability to keep paying or funding those premiums so that those assets will be there for your son or daughter out into the future. Just one of the thoughts with that, right? And so, one of the things with the tip is that you make sure that there are specifications, distributions, that thought process in mind that says, wait, I've got this situation, my child, son, daughter, whatever the case may be, that needs to have these assets set aside for them, and make sure that the power of attorney includes that as part of the process.
Just to be clear, your agent isn't your financial agent or your
Correct.
Or your sports agent, your attorney. It's the person you're designating, correct?
Correct. That is correct.
Yeah. Okay.
And so then we get into the healthcare conversation, right? So Massachusetts, now we're dealing with Massachusetts. That's where we're at, and every state is different. But generally, the three pieces that you are going to get are going to be the last will and testament, a durable power of attorney, and a healthcare proxy here in Massachusetts. Just about every other state, you're going to get what is known as a living will, right? Difference between a living will and a healthcare proxy is living will says I'm going to dictate what I want to see happen for my care and my end of life situation. The healthcare proxy says I designated somebody else to step in on my behalf, almost like a durable power of attorney, but for my health care. And that's where this slide comes in and says, I'm designating that person to act on my behalf and make the decision for me when I become incapacitated or I can't make that decision. Now, in Massachusetts, we also have a MOLST form, which sort of goes hand in hand with the healthcare proxy, which is like a living will and just sort of designates, hey, end of life decisions, this is what I would like. But the limited power of attorney, when we slide this into the special needs community, talks about the ability to have those conversations with medical professional about care that's being given. And that's really the reason that we're bringing it up is that, there's, when we get into guardianship, and we'll talk about that in a little bit, that's more the emphasis here. but this ability to have those conversations, whether or not the outcome is necessary, you want to be able to be involved is really what it is. All right. So, some of the things that really, as we move from typical family to family in the special needs community, that we talk about, right? And one of those is that letter of intent. So much like we talked about the documents that were involved and guardianship and dealing with it. So one of the things that with a letter of intent to be thinking about here, and we'll get into that in a second, but we'll talk about guardianship later on. Letter of intent is not a legal document. We bring it up as part of a legal document because it does get referenced. The courts will look at a letter of intent that you put together for your child. And the idea here, think of it as, Craig, how did you read the handbook for raising the child, or,
I always say, like I said, when my children are born, I wish they had come with an owner's manual. Like Robbie the robot.
Yeah, owner's manual. That's what it is, right? So an owner's manual for your child, right? And that's what you sort of need to be thinking about with this. Is that wait, I've got my child that I'm trying to get in there, and so you want to have your child's biography, their medical history, wishes as far as living arrangements, education, religion, right? All the things that you can think about. The likes and dislikes, and we talk about that, we want to get very, very specific about this, right? So, favorite colors, nighttime rituals, religious preferences, favorite foods, educational arrangements, the medical professionals, teachers, who they like, who they interact with. All of that is something that needs to be considered and should be put in the letter of intent. And one of the tips that goes along with that is this isn't, all right, I'm going to sit down and write this, when the child is, we usually say to start it like when they're like 10 or 12 years old, and then that's it. No, it should be this ongoing morphine, document that gets reviewed once a year. And whether that's on their birthday, whether that's on the first day of the year or the favorite holiday the child might have, whatever it is, just so you remember at that time, hey, that's when I want to reach out, look at the letter of intent and see what's gone on over the past year. Have there been some changes? Have there been updates? Maybe it's no longer Star Wars and now it's The Mandalorian. I know that's Star Wars too, but you get it. There's, maybe some other type of thing, right? That goes along with that.
Baby Yoda,
Baby Yoda, right? That there's a favorite toy now or something that really, that the child really is into and wants to deal with. It's those type of things that you want to make sure is kept as part of it.
Right? Well, the other thing too, Tom, is this is a letter of intent isn't just if you pass away. It also is, let's say you decide to take some respite, and go away for a weekend or a week or something like that, and your child is staying with your parent or an aunt or an uncle, then they at least know have all that information available to them as well.
Right, absolutely, and it's a good point that's why it should be something that gets updated and kept along with it. This just talks about, again, we think it's very, very important. That's why we keep bringing it up. Those favorite leisure activities. Case managers, doctors, dentists, therapists. Even the barber. Like Craig keeps making fun of me. My barbershop down the street, they closed because of COVID-19 and never reopened. So my wife and I have sort of been hacking away at my hair here because I don't have another barber. That was my barber. That's where I went. And so it's one of those things. And that might be the case with your child.
I wasn't making fun of you. I thought you did a decent job.
But you also want to keep in there legal and financial information, right? Where all the documents are that relate to the child, that should be in the letter of intent as well. You should always have the ability to be able to touch in and be able to reach and get a hold of any of that information. All right, so guardianship. We like to use this quote when we're talking about, with organizations about guardianship, is the only way I can make sure that his mom or I will be able to advocate for what is necessary so he will be safe and happy. To secure this, I must prove to a court that my son is incapable of making decisions on his own. My wife and I must also choose someone to accept this responsibility when we are no longer alive and who we can trust to carry out our wishes. Now, that is from the gentleman who is the chair of the Long Island chapter of Autism Speaks. But we think it brings it home, the whole concept of what guardianship really means when we're dealing with a child who's differently abled or has a disability. It's not my underage children. It's now my child has reached age of majority and is adult, and what do I do now, right? So a guardian is a person lawfully engaged. They're given the power and charged with the duty of overseeing a person who is considered incapable of acting or administrating for their own affairs. That's really the idea of a guardian. You know, the same concept of you with your minor children, anyone who's under 18, it's that same concept. Now it just carries forward that they are an adult. Designating a guardian is a critical aspect of drafting a will. This is why we brought the will and testament in the first part of this, whether it's for minor children or a legally incompetent adult, somebody unable to act on their own behalf.
Well, and that's a good point too, Tom, because how many people do we deal with? We're talking about a 16 or 17-year-old child. Sometimes it's a 40 or 50-year-old child with a 70 or 80-year-old adult parent caring for them.
Right, right, and it's really about dealing with this. That we're talking about now having the child get to what is known as age of majority, which is they've reached 18. Once they are 18, they are now an adult in the eyes of the law and the courts, right? And the question becomes what every parent sort of needs to go through in this process is the child, the individual, incapable of making medical or financial decisions on their own behalf? And if that's the case, then legal guardianship should be a course of action or a consideration is the better way to put that, right?
Tom, sometimes I think I get from clients a pushback if they're afraid to label their child as incompetent. So they're afraid to go to court because they think, well, they can make some decisions, but not all of them, but I really need to go to court on that. Can you give up part of that guardianship?
Correct. Right. So, so that's part of it. And that sort of leads in, with the next, which is, as far as guardianship concerned and whether or not, how I do and what I do. Right. And do I need to retain counsel to do this?
Okay.
Right. As far as, and we'll get into a little bit more of that in the next slide or two in terms of partial conservatorship and that type of thing with where you went with that. But, one of the questions is, what do I need to go through and do I have to have a lawyer in order to do this? Right. Well, the concept is no, you don't have to. There's a lot of documents that need to get compiled and put together and amassed in order to go through the process. You can do all of that on your own.
I do my own plumbing too.
Right. However, you do have to go to court and to present all of that. Can you do that on your own? Yes. Should you? No. That's, our opinion is that no, that if you're going to go through this process, you're going to require or request legal guardianship, that you should have somebody, an attorney, like we talked about at the very beginning. If you've got, legal questions, go to a professional and talk to them, right? In the case of guardianship, you can actually appoint what is known as it's LAR, I believe, the limited assistance representation. That's what it's called. Right, where it's not hiring them on for it's usually like a flat fee, a small dollar amount. I don't know what it is here in Massachusetts, but you can go through it. But that's what you're looking for, is somebody who's specifically just going to guide you and help you through getting guardianship, of getting the documentations and presenting that to the court for the purposes of becoming the guardian of your child. So what is guardianship, right? And where do you file, right? So it's a legal process. That's the whole idea. And you've got to do this before the child becomes age of majority, age of 18, because once they become 18, then they're a legal adult and it's a different conversation. Similar, same process. It's just a little harder, Craig, right? As far as going through trying to get an adult versus a child not yet an adult.
Right, because the issue is that the adult child, the 18-year-old, can dispute it, and now you've got to prove that that they are incompetent as an adult to make their own decisions.
Right.
Just a much more difficult pushback.
Right. And so now to bring up the question that you had asked before, which was, that sort of, again, the type or guardianship that, depending on the child's impairments, as far as guardianship is concerned, it can be limited. There are areas where you can limit in terms of the child's ability to make their own informed decisions.
Mhm.
Right. So, if you really think about it, the idea, the goal, what guardianship is trying to do is it's trying to protect the child's rights while also granting them some kind of independence, but it's also meant to protect their health, safety, and well-being. That's the whole idea behind it.
Right, so they may be perfectly work a job, live on their own, maybe even drive a car, but maybe when it comes to getting into contracts, like buying a car, buying a house, setting up a retirement account, managing, those types of things, they may need help in those areas.
Right, or it may be something simple as just being able to negotiate or have conversations directly with somebody. A lot of times it's nonverbal in terms of going through that. So,
Social
yeah,
aspects.
that can go through. So the filing, it takes place. It's in probate and family court in the county where you reside. So wherever county you reside in the case of our office in Newton, we're in Middlesex County, we would file in Newton, in Middlesex County as far as the probate and family court. And that's where you file the petition. Right. I am considering these are some questions that have come up, over time that we try to deal with. I'm considering guardianship for my special needs teen. At what age should I begin the process? Well, at the end of this, I'm going to go through a whole sort of a timeline with you, talking about the different steps and different phases and going through that. Really, our recommendation is 17. Part of that now is COVID. Right. So COVID is delaying everything. We did this presentation for one of the Seven Hills organizations not too long ago. And some of the conversation that came out of that was, the courts were not even open to have conversations at this time. They were, there had been delays and problems with getting court dates. I believe the courts reopened in August, but who knows with what's going on now and what the governor is starting to put in place and how that's going to react. Right.
And the other issue too, Tom, is it's not about when you start the process, it's about when it ends. So if you're in start this is, 16, 17 and a half, and they turn age of majority in the middle of the process, well, now it changes the whole thing. Now you got to go back in after an adult guardianship versus a child's guardianship.
Right. And it is a 6 to 9 month process. That was before COVID.
Mhm.
Now with the quarantine and everything that's going on, it's even delaying it longer. So that's why we say at least 16 and a half to 17 is the timeline to start that. What are my responsibilities as an adult child's guardian? It's in full guardianship. You're responsible. Medical and personal decisions, everything. In limited guardianship, it depends on what you're able to have that conversation in. If it's just related to, like Craig said, if it's related to medical reasons, that's one factor. If it's related to another part, we'll talk about conservatorship in a little bit, but that might be more financial. And if that's the case, conservatorship might be the way to go versus guardianship. All right. This is all spelled out. This is what the judge is going to consider. This is why having that limited assistance representative, the LAR, the attorney, along with you, is why you want to have somebody there so they can certainly make that clear exactly what you're trying to get. Now, if there are more involved and, you know, as far as medications are concerned, there is what is known as a Rogers monitor. We'll talk about that quickly right at the end of this, but that's something that comes into play that's a little bit different. But for the most part, your responsibilities are that you've got to see to the well-being and care of this individual for the rest of their life, right? So, what are the forms? A medical certificate. This is something that you get. This is usually done within 30 days of filing the petition. And this is why this gets a little bit, like we talked about, a little bit stalled in terms of the process, because you've got to get somebody who can come in and sign off on this, right? Usually a licensed psychologist or certified clinical specialist will do this MPC 400. Again, we're in Massachusetts, so just understand these are the forms here, right? You're filing the petition for appointment of guardian for an incapacitated person, right? That's part of going through this. And while there is a bond that is asked, and the bond is just that, hey, I'm going to be overseeing and taking, the oversight of this individual. So a lot of times they'll ask you to put up collateral or put up some kind of surety, for that. In the case of a lot of times when it's the parent of a child, they'll waive it. There's usually not anything that's going to come with that, but just understand that sometimes the question or cost of, the funding of a bond might come into conversation with it. The clinical team report, this is done usually within 6 months of filing the petition. A lot of times this is that same, it's a physician, a social worker, or a licensed care manager. A lot of times they can do both with the previous MPC 400 and this one at the same time, be the same people, if you will, as far as going through that. And a Rogers Authority, I mentioned it because that's when there is antipsychotic medications treatment that the court is mandating or expecting to happen, that someone needs to be appointed for that, and that there is an ongoing and annual monitoring and reporting that these medications and that care is being done. So this is the part that Craig asked about, right? Conservatorship. So conservatorship is a little different than guardianship, because conservatorship is really talking only about managing the financial aspect, right? So maybe, able to, do things on their own, but when it comes to the nuances and ins and outs, like Craig talked about, signing a contract, getting a credit card, buying a car, leasing something, those might not be concepts that are really going to resonate with the individual. Therefore, it might make more sense that instead of guardianship, you just want to be a conservator, which just says you're going to be able to act on their behalf when it comes to matters that are financial. Now, a lot of times you will be in the situation where a Social Security check is coming in and that you will get the rep payee status for Social Security. So you will be sort of guiding them through that, being able to sign off, deposit the money in the bank, that type of thing. But just understand that if you are appointed as a conservator or even as a rep payee, that all of what you're doing is really acting as a fiduciary for the individual. You are guiding and then going to be making sure that any of the money that is spent only for the individual, that any of the funds, any of the money that is taken out, whether that's out of their bank account, out of a special needs trust, wherever it's coming from, that is a responsibility that you will oversee and oversight that is to their best interest, and you will follow through on that, and you will report on it on an annual basis to say, this is what we used, these are the funds that we took out, and this is what we did. Sorry, I need to have a drink. You're also able to defend them, as you can see, right to be able to dispute any charges or any filing that might come against them or any claims against them from a standpoint.
Tom, can somebody have guardianship but not have conservatorship, and vice versa?
Yes, so you can again, guardianship is sort of the whole mantra. You're doing everything. So, but conservatorship is just for the financial world.
Okay.
You don't really, if you're not going to have a medical conversation. If you have conservatorship, you can't be involved in any of the medical conversations.
Okay.
Right? Because I'm just involved in what is now financial aspects.
You can pay the medical bill, but you can't.
Right. You can sign off on the health insurance payment, but you can't have a conversation with the doctor.
Gotcha.
Okay. So the timeline that I talked to you about, so this is sort of the considerations when we talk about transitions. Really, by age 13 is when we suggest that you've started to put together some of those thoughts, starting to look at, where the trajectory or path that the individual is going to be taking. Certainly by 16, that transition plan is starting to go into place. And by 17, like we said, somewhere between age 16 and age 17, the recommendation is that you have started to go through and if you made the decision about guardianship, whether it's full guardianship, whether it's partial guardian, limited guardianship, or whether it's conservativeship, you started that process and started yourself through the motions by age 17. Because by age 18, they're an adult. You're no longer in the conversation. You no longer can participate in anything. 19, actually 18 through 22, this is where, a lot of the vocational services, they're still involved in the school, able to get those benefits because they don't age out of the system until age 22. And then at age 26, at age 19, it talks about, filing for health insurance. But if you're keeping them on your health plan, that happens all the way up until 26. And then at 26, you need to be looking at getting them their own health insurance and dealing with that.
And Tom, we're at about 41 minutes right now.
Right, and we're coming into the close. I certainly appreciate that. That's why Craig is here. So final thoughts. So, what we say to everybody is anytime we go through these, that the number one thing is to make sure that you have, create, or continue with that letter of intent. If nothing else, that's what you put in place and start to build on. Put together a timeline transition. I know it's difficult. I know it's hard. Like Craig said, some of that is a stigma. Some of that is a concern, but it's important. It needs to be looked at and needs to be dealt with, and make that decision by age 17, because it is an ongoing process that in today's world is probably taking closer to the 9-month window than the previous 6 to 9 months. And at a minimum, have a durable power of attorney, because at least as a durable power of attorney, you then have the ability to sort of have that conversation and act on their behalf. And the last piece in that is, it's always about future funding when you're not around or not in the picture anymore, and that you want to make sure that there is some sort of a trust or some sort of fund available for the individual. This is Craig and I in our other world when we're having more fun and doing stuff that we do. That's our contact information, but we tend to, again, we take the information we share with everybody very, very seriously. We try not to take ourselves too seriously, and we always have fun out there, but that's some of our contact information. One of the things we do make available for everybody is we have a monthly newsletter that lets everyone know all the different organizations that are in the special needs community have events. They have trainings, they have, conferences and different events that go on now virtually more than anything else. But this newsletter it puts them all together, and we just blast it out on a monthly basis. The next one's going out tomorrow, I think, to everybody, just to let them know, hey, here's what's going on for the next 2 months. And if you have organizations or want to take advantage of some of the trainings or the opportunities that are out there, it's a great thing to get on. You can just reach out to us and let us know to put you on that newsletter list. We'll send everybody out an evaluation form. We'd like to just get that feedback, because we do these presentations not only throughout the region for organizations and community groups, and like to make sure that you're getting something out of it. Part of that is we make an offer to everybody. If you've got some questions or concerns that you're not comfortable with sharing in the chat room, just reach out to us. We'll certainly answer it. We also have a step-by-step guidebook. It's sort of this presentation just laid out in a more of a step-by-step basis for parents. So if you're interested in that, we certainly can get that out to you. Again, there's no cost or charge for any of this stuff. And then what's on tap? We got some great stuff coming up. We've got next week, we're going to do workplace accessibility. We've got the Cowell Center for the Blind and a company called Good Maps. That's a software mapping company talking about how to make work sites more accessible for those with disabilities. On the 17th, we're doing a virtual networking and wine tasting. That's to benefit Rosie's Place here in Boston. On the 19th, we're going to do healthy and wealthy holidays. We know stress during the holidays tends to lead to two things. I overeat and I spend too much money. So we're going to try to help you get a little bit, handle on that. And on the 26th, obviously, we won't be doing a presentation. That's Thanksgiving. Even though it's been a crazy year, we do want to say thanks, and we are grateful for everybody who's been helpful to us in getting through this trying year.
Hey, Tom, just because you started with, Hammerhead, the Hammerhead beer there,
Yes.
right, which would reference Jaws. I didn't know if you could maybe take us out on the twin version of My Spanish Lady.
No. Any questions out there?
No, once again, we've done such a fantastic job that we've answered every question.
Okay. So the last one is how to get in touch with us. If you want to have any of those, whether that's to get on the mailing list, whether it's to, set up to get that step-by-step guide, we're happy to, send that out to you. It's info@ariesfoundation.org, or you can call us directly at 617-431-5045. I certainly appreciate it. We ran a little over. We try to keep these at 45 minutes, but we do appreciate it. I want to say thank you, and I am going to stop my share and say good night.